First at 5:30, newly unsealed court documents providing some new insight into questions about a juror in the governor's kidnapping plot case.
Yesterday, a jury found Adam Fox and Barry Croft guilty on all charges. But will that be the final word in the case?
News 8's Joe LaFurgie has the new developments tonight.
Recently unsealed court documents reveal one of the controversies in the case, that a sitting juror told someone outside the court that he intended to convict before hearing any evidence. The accusations came shortly after the trial got underway. Barry Croft's defense attorney, Joshua Blanchard, was told by a co-worker of the juror that the juror had already decided Fox and Croft were guilty and would make sure that the defendants were found guilty. That's according to the court documents that were unsealed. Blanchard told the court the day after the trial began on August 10th, but rather than delay the retrial, testimony proceeded with the juror still taking part in the case while the court's jury clerk investigated the allegations. According to the unsealed court brief, the jury clerk called the person who alerted Blanchard to the conversation and told the court while there was some similarity to the information Blanchard provided to the court, the information was different in several material aspects. Specifically, the jury clerk found the coworker had not talked directly with or heard anything from the juror. Quoting from the court brief, the caller was simply reporting a second-hand report from someone else about what that other person reportedly heard from the subject juror. Moreover, the jury clerk was unable to confirm the report with the other coworker because that coworker had reportedly expressed a desire not to speak or otherwise be identified, and the person who did call refused to identify the person. The court passed on the information to the prosecutor and both defense attorneys on August 11th. The juror was called in to Judge Robert Yonkers' chambers after testimony for more follow-up, but without any of the attorneys, including Blanchard and Fox's attorney, Christopher Gibbons. Blanchard and Gibbons objected. From the court brief, Attorney Blanchard also expressed a concern that the subject juror was somehow manipulating the jury during trial to ensure an allegedly desired outcome. Attorney Blanchard asked that the entirety of the jury be questioned on the matter with the parties present or that the court declare a mistrial. The court disagreed and Blanchard filed an objection arguing the court's decision violated Croft's rights. The juror in question was eventually interviewed and denied making the statements. The subject juror's behavior during trial buttresses this conclusion. Interaction with other jurors, to the extent court personnel can observe it, evidence no hushed whispers or any other indicia of a desire to manipulate. And the juror's behavior in the jury box is entirely inconsistent with someone who has made a predetermined decision to find the defendants guilty. The juror has consistently been attentive and engaged during both the government's presentations and each defendant's cross. The juror has taken notes when defense counsel have made what were, in the court's mind, especially good points or broke new ground, and even when, in the court's view, the points were not particularly strong, wrote the court. The brief goes on to call the original reports of the jurors' alleged statements about their predetermination of the case as double hearsay. But the reporting individual did not hear any statements from the subject juror and did not even know personally if the juror was on the case. And the co-worker who allegedly did hear the remarks is unidentified and unwilling to be identified or to speak with the court's jury clerk, nor would the reporting caller identify the person. With that, the case moved forward, ending in Tuesday's conviction of Adam Fox and Barry Croft. Both Blanchard and Gibbons declined to talk specifics of the juror allegation following Tuesday's verdict, and if that decision may be part of a potential appeal on behalf of Fox and Croft, who face up to life in prison at sentencing. But W.M. Cooley law professor Jeffrey Schwartz predicts the question over the juror's service will be a big part of an appeal.
And I assume that the motion was supported by affidavits. That if there aren't affidavits, that they will get affidavits from them and supplement the record on their motion for a new trial.
But is that the only controversy that may resurface? We'll talk about that at 6 and hear from the victim targeted by the kidnapping plot, Governor Gretchen Whitmer. In Grand Rapids, Joe LaFurgie, News 8.